Hello, and welcome to Law and Democracy, a podcast of the election law program at The Ohio State University Moritz College of Law. Our guest today is Professor Dan Tokaji, who we are thrilled to have back on our podcast. Dan is the Dean of the University of Wisconsin School of Law and one of the most distinguished election law scholars in the nation, as well as a longtime member of election law at Ohio State. And we are so happy to welcome you back to the podcast, Dan.
Well, it's a pleasure to be here, and especially a pleasure to be with all of you, my dear friends and former colleagues from whom I have learned so much over the years.
Well, thank you, Dan. Our topic today is redistricting, which was in the news again this afternoon. The Georgia legislature announced that it will not be redrawing its lines in advance of the midterm elections. That was a surprise. The Georgia legislature, some members of it had indicated that they intended to eliminate the state's majority-minority districts. But the word today is that that will not be happening in Georgia, though, of course, it is happening in other parts of the South. And so, Dan, I think the best way to begin is just to get your impressions of where we are today when it comes to the Voting Rights Act, when it comes to racially motivated gerrymandering. How do you make sense of both the recent U.S. Supreme Court rulings and what we're seeing happen on the ground?
Yeah, well, I think we're in a really bad place from my perspective when it comes to redistricting, including claims of race discrimination in the voting process, as well as partisan gerrymandering, although there are some bright spots with respect to the latter issue. So with respect to the Voting Rights Act, we've now seen the last major component of the Voting Rights Act fall with the Callais decision earlier this term. The first to fall was the preclearance requirement of Section 4 and 5 of the Voting Rights Act, now more than a decade ago in the Shelby County case. The next to fall was in the Brnovich case, vote denial claims under Section 2 of the Voting Rights Act. The court didn't exactly destroy those claims, but it made it much more difficult for those claims to prevail with the way it interpreted Section 2 of the Voting Rights Act in that case. And then the last piece to fall are vote-dilution claims under Section 2 of the Voting Rights Act. That's the claim that a particular group has not been denied their ability to cast votes, but their collective voting strength has been weakened. And just to give a bit of an overview of this, some of your listeners and viewers may already know this, but this has to do with a provision of the Voting Rights Act that has been part of that statute since the 1982 amendments, which were intended to respond to an adverse Supreme Court decision, City of Mobile versus Bolden, which had effectively said that Section 2 of the Voting Rights Act requires a showing of discriminatory intent in order to prove that a particular racial group's voting strength has been diluted in violation of the statute and the Constitution. What Congress did in response to that was adopt language that allows for a violation of the Voting Rights Act to be found upon a discriminatory result that is not requiring intent. And the Supreme Court, a few years later in the Thornburg versus Gingles case, interpreted that language in a way that I wouldn't say it made it easy to prove vote dilution, but provided a very manageable standard where if you could show that there was a concentrated racial group and that there was polarized voting, meaning the majority racial group voted one way and the minority group the other, you had a strong chance of prevailing on that claim. And that has been the standard that has guided us since 1986. So for around 40 years, that standard is effectively eliminated after the Callais decision in a way that I think will make it practically impossible for minority plaintiffs to prevail on vote dilution claims. I would love to be wrong about that, but I think it's going to be quite difficult.
Dan, what alternative do you think the court had in light of its past precedents? And in light of the fact that you have a conservative majority in the court, could you have imagined a less sweeping ruling, and if so, how so?
Yeah, it's a great question. And I think there would have been a much sweeping way for them to resolve the case the way they did. And that would have been by saying that the Louisiana legislature violated prior precedent by setting a numerical target that is specifically saying there had to be a majority or more voters in the particular district at issue there. I think that would have been quite consistent with earlier precedent and wouldn't have required this wholesale rewriting, in my view, of Section 2 of the Voting Rights Act as it's been interpreted for 4 decades.
So, can I ask a really big picture question about where you think we are and are headed? I think of the Voting Rights Act itself as being an attempt to achieve or accomplish the underlying intent of the Civil War amendments, and that those amendments had largely not succeeded in the voting arena in particular in the way that they had been intended. And so Congress enacted the Voting Rights Act to try to effectuate what was behind those Civil War amendments with respect to voting. And so where are we now with respect to that issue?
Yeah. So first of all, to pick up on what you said, I think you've got it exactly right. And I'm relying here on some really great recent work on the 15th Amendment by Travis Crum, who, really points out that political equality for newly freed African Americans was at the heart of the goal of the 15th Amendment. What we do know, this is, I think, pretty well established, is that when Congress was drafting these provisions, when they were adopted, the 14th and 15th Amendment, they were really thinking about Congress as being the primary enforcer of the rights that they were creating, including rights of equal protection and the right to be free from racial discrimination in the voting. Of course, nowadays we think of the Supreme Court as the primary enforcer of our rights, and that's actually a bigger issue and in my view, a bigger problem in where our law and the relationship of the courts to the other branches of government has changed over the decades. But most certainly the Voting Rights Act was intended to effectuate the purpose of the 15th Amendment in particular, first in removing barriers which were virtually ubiquitous throughout the South to African Americans being able to vote at all through the 1965 legislation. And then through the 1982 amendments that added that results language I alluded to earlier in stopping the dilution of African American votes, especially because after the Voting Rights Act, the original Voting Rights Act became law in 1965, Southern states no longer able to prevent Blacks from voting entirely adopted various creative ways of diminishing the strength of their vote, most notably at-large elections and multi-member districts that basically prevented African Americans from electing their preferred representatives, even in places where they would have otherwise had the numbers to do so. So that's the problem that the 1982 amendments to the Voting Rights Act were intended to solve, and solve it they did. I've written a few articles and book chapters on this. That act was remarkably effective in increasing representation, especially for Latinos and African Americans. And I think we're at real risk of seeing those gains fade away because racial polarization, especially in the South, is still quite extreme. Now, the wrinkle we have now is that it is so intermingled with partisan polarization, right? And it's most notably so in the South. And that's kind of at the crux of the Callais decision, determining whether these voting patterns are really the result of race or party. The Supreme Court seems to think that it's all party, and therefore we need to require a pretty strong showing of something close to racially discriminatory intent in order for plaintiffs to be able to make out a claim under Section 2 of the Voting Rights Act.
And if I can just jump in some ways, Dan, I think it's even worse than you're portraying it in terms of Callais was bad enough, but then there's this follow-on decision that seems to eliminate even claims of intentional discrimination based on race. I thought the court was wrong in Callais essentially to say that the results test was suspicious because the 15th Amendment only bans intentional discrimination. I think Congress has the power to ban vote dilution in a results test the way you've described. But even putting that aside, the second case that sort of the court says it's just applying Callais, but I think it does more than just apply Callais. I think it says you can't prove intentional race discrimination if partisanship is an alternative explanation. So I think it eliminates any kind of claim at this point.
Yeah, or at least makes it unreasonably, perhaps impossibly difficult to make out a claim of intentional race discrimination. I hope that's not what that decision means, but I fear based on where the court has been going, which seems to be to extirpate any race-conscious decision-making from any remedial laws, that may be correct.
Dan, what do you think are the short-term consequences and the long-term consequences of this series of decisions?
Yeah, I think the short-term consequences, at least the most unmistakable and obvious one, I guess, is that we're going to see fewer Black members of Congress and state legislative bodies. I think a lot of these districts are going to be redrawn, and indeed some of them already have been redrawn to eliminate or reduce Black representation and probably Latino representation throughout the states of the South, especially, though perhaps not exclusively. In the long term, and this is where I get to where I think we need to go from here. I just think it's going to be very difficult, and I'm going to maybe go out on a bit of a limb here and say, I just don't think it's going to be legally and politically viable to create race-conscious remedies for problems when it comes to redistricting. And so, if I were still an advocate in this realm, what I would be looking to are, I guess I'd call it a lift all votes approach. That is an approach that is more focused on addressing partisan gerrymandering than on race discrimination in the process. Because I think, at least in federal court and maybe even in state legislatures and state courts, it's going to be very difficult to create effective remedies for race discrimination in the process.
You mentioned earlier as well, Dan, that you saw some reason to be a little hopeful on the partisan gerrymandering front. And so that's related to what you're saying now about approaching a long-term perspective here in an effort to lift all votes, as you said.
Yeah.
And I'd really like to hear more about what you see as those.
And I think at least in the near term, there are possibilities for improving the process, especially at the state level. And on this, I've been influenced by my friends and colleagues with our state democracy research initiative at the University of Wisconsin Law School, Miriam Seifter and Robbie Ablon, who were really ahead of the curve in recognizing the increasing importance of state institutions, especially state courts and state law, especially state constitutions, particularly with the U.S. Supreme Court backing away from the protection of certain rights like reproductive rights and the subject for today, the right to vote. So I think there are real possibilities at the state. Look, in my own state of Wisconsin, we've had some changes to our Supreme Court in most recent years, which has gone from being a conservative majority court to now a solidly liberal, I think it's fair to say, court. They invalidated our state legislative districts a few years ago. We now have much fairer maps. And in other states, we've seen reform accomplished through ballot measures, through initiatives. Ohio's one of those states. I know the results have not been fantastic there so far, in part because the enforcement mechanisms are not what they might be. But other states have had better experiences with reforms through the ballot box. And so I think that's where the real opportunities lie in the short term. Perhaps in the long term, there could be some federal legislation that at least limits partisan gerrymandering. The Common Cause versus Rucho decision left that door open, it seems to me, by declaring it a political question, which means it's one on which Congress should be able to legislate. It's obviously not going to do so as presently composed, but I think there are possibilities for federal legislation that would restrict partisan gerrymandering in the future. As much as it pains me to say it, I really think that at least as long as we have the Supreme Court, we have trying to construct better race-conscious remedies for problems in redistricting is really just going to be a dead end, and that the better solution is to move towards remedies for partisan gerrymandering.
Dan, with regard to state-level solutions to partisan gerrymandering, how concerned are you about the asymmetry issue that we have seen in mid-decade redistricting, where Texas embraces partisan redistricting, and in the case of Virginia, the Virginia Supreme Court blocked the Virginia legislature from engaging in a similar type of approach? Does that worry you if we end up with just state-level reform where it ends up benefiting one party at the expense of the other nationally?
Yeah. I mean, it's especially a problem when it comes to Congress, right? If red states, let's just put it bluntly, are able to gerrymander their districts, but it's more difficult in blue or blue-leaning states, then, at a national level, we wind up with, as you put it, this asymmetry. So, yeah, that does worry me. And, the situation in California where a blue state that did redraw its districts to favor Democrats, I was really quite ambivalent about that. As you all know, I've been an advocate of gerrymandering reform, of redistricting reform that targets partisan gerrymandering. That is, for a long time, I was part of a group that included the League of Women Voters and Common Cause in Ohio back in 2012, where we drafted a ballot measure that got crushed at the ballot box. I learned my lessons about how to be more practical in this realm from that experience. But I do really favor redistricting reform and stopping gerrymandering. But then, if one side is gerrymandering without restraint, well, to make sure we've got, at least at a national level, something approaching fairness, I'll frame it as a question. Is it fair to let the other side do it as Gavin Newsom did in California? I mean, it's a really hard question for me, but I certainly understand the impulse.
Certainly eliminate competitive districts. I saw the number of competitive districts is shrinking rapidly and could shrink even more. Dan, can I come back and talk about the problem of minority or race vote dilution? Because I think you and I are on the same page where we want to eliminate partisan gerrymandering, but that's one evil in our system. But racial vote dilution is another. And I agree with you 100% that the Supreme Court has said you're not going to have race conscious remedies because that triggers it's doctrine on that. But what upsets me most about Callais is not that it eliminated race conscious remedies, but it eliminated liability for the vote dilution in the first place, because the liability issue in my mind is different from how you remedy the liability.
Good point. Yeah.
And because you could remedy dilution without race conscious remedies by insisting on something like proportional representation.
Yeah.
Which is, doesn't have the government draw lines in a race conscious way. Now that, there's some issues there too, but they basically eviscerated finding of liability, not just taking away a remedy. So that's what really worries me about where.
Yeah, and when I'm using the term remedies, I'm using it more in reference to Congress's remedial power under the 14th and 15th Amendments. That is the kind of legislation that it can draw. But I think your description is exactly right, sadly, Ed. I don't really see any room for Congress to do anything meaningful after this decision. I'd love to be proven wrong on that. That is, when it comes to racial vote dilution. Maybe there are things that states could do. How likely are the states where this is the biggest problem or likely to be a biggest problem to do those things? Probably not very likely. So I think we're in a real fix when it comes to addressing racial discrimination, particularly in the vote dilution realm. It's hard to see how either Congress or states can do much that's going to be effective. And, to the earlier point, it's exactly right that these are two different problems. They are sometimes overlapping, to be sure, right? And Section 2 was in some ways a kind of hedge against excessive partisan gerrymandering, particularly in the South, where conjoined polarization, that is racial and partisan polarization, is so profound. They are different problems, racial discrimination and partisan gerrymandering. But I'm saddened by the fact that I just don't know how much room there is as long as this court sits to do anything on racial vote dilution. But that said, I'd welcome creative ideas, and maybe there are some that are race neutral, but could still have the effect of diminishing race discrimination in voting.
Do you have a view on proportional representation systems?
Yeah. I saw there's a letter or a memo that I was asked to sign circulating. I don't have a well-formed view, but I do have the view that it would involve a major change to our system from the way that we have traditionally done things. And so, I feel this way about a lot of the proposed reforms, whether it's proportional representation or fusion voting or instant runoff voting or Condorcet voting, which you and my colleague Nate Atkinson have done some really great work on. I think that experimentation at the state level is really what's in order right now. And I would love to see experimentation where we can see how different sorts of things work and then make judgments on that before moving to reforms at the federal level, where, at least at the present time, they're not really possible anyways.
Dan, you had mentioned Rucho in Callais and Milligan. The court basically stated that partisanship is an absolute defense to a claim of racial discrimination. To play out the scenario you described, in which potentially down the road a Congress might pass a statute that bans federal redistricting partisan gerrymandering. If that were to happen, do you think that could sort of in a backdoor way undermine the Callais ruling and Milligan? Because would then partisanship still be a defense?
I think it would reduce the damage that is being caused by the Callais decision, particularly in places like the Deep South, where racial polarization and partisan polarization are so closely overlapping, right? That, the Supreme Court has to be, it may be hard to, it's easy to escape this if you just read Callais, but the Supreme Court has said in Rucho and has not withdrawn from its position that Congress has the power to address partisan gerrymandering. And so if we had effective federal legislation that restricted partisan gerrymandering, that would have the effect not of ending racial vote dilution, but of reducing it in those places where party and race so closely overlap.
So I've got another question, but Terry, do you want to jump back in, or Steve?
I think Steve had started to ask a question earlier.
Well, I was just thinking about your comment earlier, Dan, about a short-term impact being the loss of a number of majority-minority districts in the South. But then wondering if we have any particular thoughts about what happened in Georgia, which Tony mentioned at the top of our recording today, where they've, at least for the next cycle or two, I think through 2028, have said that they're not planning to take advantage of the Callais decision to allow them to redraw their districts in a way that would eliminate those majority-minority districts in Georgia.
Yeah.
And is that entirely, I guess, a political decision by the GOP leadership in the state? Or what else do we make of this new development today?
Yeah. I haven't been following developments in Georgia, Steve, closely enough to give you an informed answer to that question. But, there are unquestionably circumstances in which it's in the interests of the majority party to keep districts as they are, rather than redraw them. And it's especially in the interests of incumbent office holders from that party to do so. After all, these are people who got elected from the districts as they exist right now, and may very well like the districts they have. If you redraw the Black or Latino opportunity districts in that state, that's going to have an effect on other districts, and that may be to the disadvantage of incumbent office holders, even if it holds out the possibility of that party, the majority party, which in this case would be the Republican Party, being able to win more seats. So incumbent office holders don't necessarily like it when districts are redrawn, even if there's a possibility that it might benefit their party. And I should say, too, from the standpoint of the party's interest, we saw, this is now a few decades ago, some what were called dummymanders drawn by, at that time, the Democratic Party, which still held control in some states, where they cut their margins too tight and wound up losing seats as a result. And so, there is the possibility here, especially in a year like this one, which could be a way of Democratic year of Republican legislators doing a similar dummymander that seems like it might win them more seats, but at the end of the day winds up cutting their margins too tight and reducing their representation.
Yeah, Dan, on that very point, a number of political scientists have made similar observations. And it's just looking at Georgia, I pulled up Georgia's Secretary of State website. It's really striking. The Republicans have 9 seats in Georgia and the Democrats have 5. But if you look at the actual election returns in 2024, Trump won 50 to 48 over Kamala Harris. So it's extremely close margins statewide. And the U.S. House total was very similar. I think it was 52-48 roughly for the Republicans. And then when you look at the Democratic districts, the Democrats are winning those majority-minority districts by massive margins. In one case, I think the 5th district, the Democrat won with 85% of the votes. There's just a staggering level of wasted Democratic votes under the current lines. So it certainly would seem there'd be great risk in a state like Georgia, unlike Louisiana or Alabama, where it's a 65-35 split. You can break up majority-minority districts and eliminate all Democratic seats in Alabama or Louisiana, whereas in Georgia, it would be impossible. And where you really do face a dummymander possibility.
Yeah, very interesting. Yeah, very interesting. And this is another dynamic that's at play here, which I think of in part because it shows how much things have changed since, where we were in 2004, where Ned, Steve, Terry, you and I were, starting the election law project together. And at the time, you have a high turnout election. That was generally a good election for Democrats. And of course, the presidential general elections are higher turnout elections than midterm elections. Nowadays, it's the reverse, right? The higher the turnout, the better it tends to be for Republicans because of the way that the parties have completely shifted in that time. And the relevance here is we're coming to a midterm election, which is likely to be, is certain to be a lower turnout election than the one that we saw 2 years ago. And that's probably going to favor Democrats. We're likely to have a much more Democratic electorate, even putting aside the popularity of the president at the present time, which could skew things even further. And the relevance to gerrymandering is particularly in that kind of environment. If Republicans cut their margins too close, they may wind up paying for it.
And Dan, do you want to follow up on that a little bit with some of the other voting changes that I keep wondering why you would want to impose more hurdles if what you just finished talking about is the case?
Yeah, it's so fascinating. I think we might have talked about this a little bit last time when I spoke with you all, but this is one of these areas where the policy perhaps hasn't caught up with the politics, or maybe it's the reverse. The politics haven't caught up with the policy. That in these days, you would think the Republican Party would not be too keen on making it more difficult to vote. Because, this is now a party predominantly of non-college educated voters. They've become the blue-collar voting, especially when it comes to white voters. And so, you'd think it wouldn't be in the Republican Party's interest to raise barriers to voting, which might deplete their own turnout. And, college-educated voters tend to be less seriously affected by burdens on voting. They're going to find a way to vote one way or the other. Nick Stephanopoulos, my casebook co-author, has done some really interesting work on this question. And it is a little head scratching, but I think part of it is just, like, the parties have gotten so used to these positions, with the Republican Party going back 20 years, 24 years now, to the battles over the Help America Vote Act. And even further, the Republican Party has been the party of integrity, and the Democratic Party the party of access, even though it's not so clear that those positions actually are in their self-interest anymore.
Can I follow up on Steve's question there about which I think unfortunately is the correct prognostication, that Georgia notwithstanding, that we're unfortunately in the short term we're going to see a significant loss of minority representation in Congress.
Yeah.
I mean, we're all law professors, not political scientists or historians, but Dan, you as a dean of a law school are in a position of institutional leadership and a sense of social responsibility that comes with that. And I just worry that every action has a kind of a reaction. I mean, I can't imagine that a community that perceives that its political power has been ripped from it as quickly and as ruthlessly as has happened over the last few weeks, going to sit by and sort of let that just happen. And so, what the social consequences are of that, I don't know that I can foresee, but I'm curious as to whether you have any thoughts about that.
It's a great question, and I'm not sure I have any brilliant thoughts on this, Ned. But your question reminds me of what was happening now, starting like 20 years ago, when we saw this wave of voter identification laws, in particular, starting in Georgia and then Indiana and then spreading to other states. And people in communities of color, especially African American communities, were very concerned about the effects of this law. And I was too. Like I have been and remain opposed to the strictest voter ID laws. But over the course of time, my concern about those laws has diminished, because as the empirical evidence has come in, they don't seem to have as big an effect on turnout as I thought they would back in 2005, 2006, when we were still first coming. We were first starting to see these laws. And why is that? Well, I think a part of the reason why that is because it spurred a counter-mobilization on the part of communities of color, and especially Black communities that were incensed, and for understandable reasons, after people having fought and marched and suffered and in some cases died to protect the right to vote. The mindset in the Black community in particular was, we're not going to let you take our vote away. And so people counter-mobilized in response to these barriers to voting and found ways to make sure that they didn't have the impact that was feared and maybe at least by some hoped. And so, we didn't see huge drop-offs in turnout. I can't prove that it's exactly because of that counter-mobilization, but it might be. And so you wonder what might happen in response to this. Will we see some sort of counter-mobilization? There is this problem that we discussed earlier, that I think the Supreme Court's decision makes it very difficult to write laws that are going to address racial vote dilution. But there might be other things that can be done. And I think I'm partial towards reforms that would, in one way or another, address partisan gerrymandering, even though they don't directly get at race discrimination. They may indirectly help.
On that point, Dan, it is interesting to see the beginning of a discussion in some northern states among the Democratic Party professionals over whether they should eliminate their majority-minority districts for the purpose of threatening more Republican exurban districts. And it does raise the question that if I'm an African-American voter and a Democrat, am I better served by having a congressperson who is also African-American, but then I end up nationally with a Republican majority? Or am I better served having a Republican represent me, but a Democratic majority in the U.S. House?
Yeah. And those, I think, those are really within party debates within the Democratic Party. And look, I think those are hard questions, and people can legitimately have different views on that. And I expect they will. I don't, even if it would be I'm predicting here, which maybe I shouldn't do, but I think that in many states, the Black caucuses within those states have sufficient power within the Democratic caucus that even if there might be an argument that the Democratic Party on the whole could win more seats by eliminating Black majority districts, that won't happen. And people can disagree over whether that's the right or the best result, but there might be other states in which the Democratic Party does wind up eliminating some of those districts to increase their margins. It'll be very interesting to see, but I have to say that troubles me less than what we've primarily been talking about, which is the likely effect in red states, because it is a legitimate debate, right? Whether it's better to preserve some of these existing districts or whether it's better to draw districts in a different way.
Yeah, I mean, I'm not Black, so I'm hesitant to try to speculate, but just as somebody who's tried to understand American history, it seems to me that the oppression against Black Americans, so severely for so long in so many forms, from slavery to Jim Crow, is such that I mean, obviously we needed the Voting Rights Act, and it seems to me that for America to be a successful country, in my view, Black Americans have to feel like they are equal citizens within the country.
Yeah.
And that's a challenge given the history. And it just seems to me that if you rip away Black political power as such, it's going to make it very hard for Black Americans to think that they really are equal citizens anymore.
That's right. And
I think that potentially has some devastating consequences. I hope not, but I fear down the road.
Well, and the argument you're making, Ned, which I will say I agree with, is one most famously made, as you know, by Justice Marshall in his dissenting opinions in some of the affirmative action cases in the 70s and 80s. That the experience of Black Americans is just unique. I think you're exactly right that if we see the elimination of all, I'll call them Black opportunity districts, because districts don't necessarily have to be majority Black in at least most places in order for an African American candidate to win. But if we saw the complete whitewashing of Congress or state legislative bodies, that would incense me, and it would, we can imagine what the response would be. This sense of total disempowerment, like we're facing a repeat of what happened in the late 1800s, when African American men, at least, after voting and being elected to office in large numbers throughout the South, saw their representation between 1872 and 1900 go from over 300 to 0. This is from Morgan Kauser's work, I hope we won't see that, but I do think we're going to see, as we've already been discussing, a really significant diminution in Black and Latino representation over the months and years to come, and that is really sad.
Well, I'm afraid that's all the time we have for today, but I want to thank Dan and Terry and Steve and Ned for this fascinating and important discussion. Please be on the lookout for more episodes of Law and Democracy, and don't forget to subscribe to our channel and press like on YouTube and Apple Podcasts. Goodbye for now.